Please be seated. Welcome to the 14th Court of Appeals. We're going to have two cases on the docket, and I will be the person who disappears between them. So what we have first is 1423-473 CV, William Shepard versus Jonathan Martinez. And if we could get announcements.
Sarah Allen for appellant.
How much time are you going to reserve?
I'll reserve 5, Your Honor.
Okay, y'all have that? Okay.
Your Honor, Eric Nielsen for the appellate.
All right. When you're ready, counsel.
If it pleases the court. Reviewing courts maintain the important responsibility of ensuring that sufficient evidence supports a jury's award. The question in this case is whether certain portions of the jury's award are supported by legally sufficient evidence. The answer for that is no, for 3 reasons. First, there is no evidence of the need for any future treatment for Mr. Martinez beyond a recommendation for a single epidural steroid injection, more commonly known as an ESI. Second, most of Martinez's past unpaid medical bills were time-barred and uncollectible as of the time of trial. Therefore, they were not incurred as required by statute for recovery. Finally, Dr. Berliner's expert testimony that the auto accident caused Martinez's diagnosed disc herniations was conclusory and speculative, amounting to no evidence at all. As to the award of future medical care expenses, the standard of review was well cited by this court in the Gunn v. McCoy opinion, in which this court said, it is within the jury's discretion to determine what amount, if any, to award for medical expenses. This standard of review, however, is not so nebulous that a reviewing court will uphold a jury verdict for future medical expenses when there is no evidence, which is the case for the vast majority of the verdicts in this case for future medical care expenses. The jury awarded $120,000 in future medical care expenses, but the only evidence presented at trial of the need for future medical care was a single ESI shot, which the records provided at trial showed was charged $5,688.80.
Which begs the question, how is that no evidence? It may not be much, but is that no evidence?
Well, the reason that I believe it is for the amount in excess of that is because in the Gunn v. McCoy case, this court reviewed the evidence presented at trial, found that the vast majority of the award, it was over $7 million, was supported by legally sufficient evidence. However, there was $159,000 in the award by the jury that was not supported by legally sufficient evidence because the evidence provided showed that it was possible but not probable that that care would be needed.
Well, that raises the question of, if you're right, what is the appropriate remedy? Is it a remediator? Is it a reversal? Is it a remand on some issues but not others? What's the appropriate remedy?
I believe the appropriate remedy would be to suggest a voluntary remediature under Rule 46, I believe it's point 3, and if that was not accepted, then a remand of a portion of that verdict would be appropriate. That's been done.
Just the portion?
The portion for which there is no evidence.
All right.
So
it'd be a remand if you're right on your first point, but not on the other points, then it would be a remand on future meds only?
I don't believe so. I mean, we did bring a legal sufficiency challenge, and so it would be either render or you know, a voluntary remediature or render a portion of that judgment. There's not a factual sufficiency evidence challenge on that, so I don't believe remand for a trial on that issue would be appropriate, based on the preservation of error in this case. And I believe that there's another case that was recently issued by the First Court of Appeals, the Lara v. Bowie case, where again they did a reverse and render of a portion of medical expenses that were awarded by the jury because there was not legally sufficient evidence to support that portion. So there is authority for this court to be able to look at it and say, well, this portion is supported, but to go from $5,668 to $120,000 without evidence, it is well within the power of the court to look at that and suggest a remittiture or reverse and render a portion.
So is it your contention that the jury could not consider the past medical expenses and the possible life expectancy of the plaintiff in order to reach a decision as to the amount of medical that should be awarded for futures?
Well, I believe that is, cases talk about the fact that you can look at the past medical expenses. One thing that is clear, though, is that in this case, the doctor who was his treating physician testified at trial about the need for future medical care, only was able to provide an opinion as to the need for one future epidural steroid injection. And the reason that testimony was limited is because the need for any other future medical care was never disclosed in discovery. And that was a decision that the trial court made to limit that testimony. And I believe that has to have an impact on the award and whether or not there is legally sufficient evidence to support the amount. You would have to have some evidence to support an amount that is that far in excess as to what the records presented at trial show was the only recommended future medical care.
But the trial court didn't make any type of ruling as to the jury's consideration of past medical.
I don't believe so. No, I do not believe so. Now, the second point that I mentioned has to do with the past medical care expenses that were time barred at the time of trial. Under Texas Civil Practice and Remedies Code, Section 410105, the legislature has said, in addition to any other limitation under law, recovery of medical or health care expenses incurred is limited to the amount actually paid or incurred by or on behalf of the claimant. Of the amount that was awarded in past medical expenses, $34,781.04 was unpaid.
Do you have any authority, other than Haygood, just your general case, do you have any authority for the proposition that unpaid medical bills past statute of limitations are not, quote, incurred?
Well, the statute itself does talk about how that has to be, well, let me add to that, sorry. There is a Texas Supreme Court case called Allstate Insurance versus Forth, cited in the brief. It's on a different issue and it was decided on standing, but the Texas Supreme Court clearly said that the plaintiff had no right to sue over medical expenses for which she cannot be held responsible, or there's no exposure there.
Sure, but has any court taken the next step and said that is not, quote, incurred, close quote, under Civil Practice and Remedies Code 41?
I know of some trial court rulings, but nothing from the Court of Appeals that I found today, sir. So
okay.
It really is applying the statutory language to the facts before us and looking at what the Texas Supreme Court said in the Forth case, which is that if you're not exposed to that bill, then it is not incurred. It's not something that you have the right to sue over, and which, to me, I think lines up very neatly with the fact that it would not be incurred if you're not exposed to it. The other
well,
point.
Doesn't that mean it's in the defendant's advantage to delay the case beyond the statute of limitations and thereby cut off the plaintiff's recovery?
Well, I believe there are plenty of ways to avoid that from happening, including, tolling agreements, etc. I don't think it's something that is insurmountable, but the facts before the trial in this case did not show that any attempt to extend that limitations deadline or make an agreement for late payment was provided to the court, and so that evidence just is not in the record in this case.
Was there an objection at trial based on the statute of limitations as to the introduction of the amount of medical expenses that were incurred?
I think there might have been something, not at trial, not that I've seen at trial. We did include that in our J&OV motion that we timely filed after judgment was entered, and we brought it under a legal sufficiency challenge because I believe that if it is not collectible, it is no evidence, which is what Haygood talks about, and I think this quote is important in particular. Basically, the court says to impose liability for medical expenses that a healthcare provider is not entitled to charge does not prevent a windfall to the tortfeasor, it creates one for the claimant. So that is the reason I believe that the court has held that in order to recover for these expenses, you must show that you owe them. And that is not the case in here for a portion of the past medical expenses. The final issue that I raised is the conclusory and speculative nature of Dr. Berliner's testimony.
Before you continue with another issue, so is there anything in the record, anything in your briefs about the amount that you feel was incurred or was not incurred? Did you make a distinction somewhere and say, well, this is the amount that we think may be incurred and this is not?
We did separate out the amount that was unpaid in over 4 years. And so we would just have to do the delta between what the jury awarded for past medicals and that $34,000. I believe there's about $10,000 more above. I'd have to double check the amount that was awarded for past medicals. But we put a specific number in our briefing for what we believe was uncollectible and therefore no evidence.
If we were to accept that argument, when would the statute of limitations toll? At commencement of trial, at verdict, at entry of judgment?
I believe basically that you can have an agreement between the parties.
That's no agreement.
Okay, I understand. I mean, in this case, if it told at trial, that would not have saved this amount that we pointed out in our brief as past medicals that were already time barred. As far as when tolling, I mean, I'm sorry, Your Honor, I don't have any better answer than the fact that if the providers enter into an agreement with the patient and it meets formation of contract principles, then I don't see that would be that would preclude this argument from succeeding.
Sure.
And I see that I'm out of time, so I will step down. Thank you, Your Honors.
Thank you.
Good afternoon, Your Honors. I'm going to take their issues in reverse order, the way they did it in their brief, because that's the way that we responded, and that's the way I prepared, if you don't mind. Okay, so issue number one in their brief is that Dr. Berliner, his opinions are just speculative or whatever. They failed to file a motion for new trial, so they've lost any claim of factual insufficiency. They can only make a legal sufficiency argument. No matter how many times they say that Dr. Berliner's opinion is conclusory, it's clearly not. They are required to show that there is not even a scintilla of evidence to support Dr. Berliner's opinion. Before doing that, though, I want to point out to the court that one of the things they rely on heavily in their brief is some sort of argument that Dr. Berliner didn't take into account that repetitive lifting of 70 pounds or something over that. There is zero evidence that my client had lifted 70 pounds repetitively. That was something that the trial counsel, Mr. Ward, brought up when he said that I've taken your deposition before. Haven't you testified that somebody can get a herniated disc from a bumper car, which is true, or that they can get it from repetitive lifting of 70 pounds? He said, yes, I'm sure I testified to that. It has nothing to do with Jonathan Martinez. He is an IT person who never lifted more than maybe 10 pounds. He said Mr. Martinez said 7 pounds of computer equipment. So that's a red herring, and really it has nothing to do with this case. It's the same as saying that an Olympic weightlifter, if an Olympic weightlifter is lifting too much weight, he can get a herniated disc. That's true. Well, my client's not an Olympic weightlifter. It has nothing to do with anything. Okay. So causation, legal causation, scientific causation there are three factors to consider. Can the incident itself cause this type of injury? So for example, can a car crash cause cancer? No. That's the end of the inquiry. There's no causation there. Can a car crash cause a herniated disc? The answer to that question is yes, and the testimony at trial was that from Dr. Berliner, he looked at the photographs and said, absolutely, this crash could cause it. And Mr. Ward brought out, well, you've testified that a bumper car can cause a herniated disc. That's true. So we have yes to question number one, or part number one of the three-part inquiry. Part number two is temporality. When did the symptoms first occur with respect to the occurrence? In this case, it happened within a few hours. My client went to a chiropractor the very same day that this happened. Prong number three, the three-pronged causation inquiry is there something else that could have caused it, that could have happened in between the occurrence and the time that the symptoms occurred? So if the symptoms didn't occur for a year later, there could have been many things. If the symptoms occur within a few hours, what are the things, what other events happened that could have caused this? In this case, there's zero evidence that anything else happened. So Dr. Berliner is not required to eliminate any other possible cause when the evidence in this case is that this is a 25-year-old man at the time who shouldn't have any herniated discs whatsoever. He complained never of any back pain or neck pain. He never went to a doctor. He gets in this car crash. It's a pretty massive crash if you looked at the photographs that were in evidence in this case. He goes to the chiropractor complaining of neck and back pain on the very same day. The chiropractor does x-rays. The x-rays are both, they show abnormalities in his neck and back. He's lost lordosis, the normal, the normal shape of the spine in the neck and back is gone because of muscle spasm, which is an indication of injury. So causation, I think, is solid in this case. And his testimony is undisputed. They didn't have anybody, I mean, they're not required to bring forth any evidence, but if they wanted to dispute what Dr. Berliner said, they had plenty of opportunity to do so, but they did not. Okay. So there's plenty of evidence to support his finding of causation. We're not required to prove a negative, and that's what they're trying to put the burden on us to prove a negative. That, well, he testified, Dr. Berliner testified, well, he might have had herniations before. I doubt it seriously because a 25-year-old person shouldn't do that. But if absent an MRI before, how would anybody know that they have herniated discs if they've never had any back or neck problems? We know that it's very unlikely for a 25-year-old man to have. Afterwards, he ends up with 6 herniated discs. So I think causation is, there's way more than a scintilla. I think it's a slam dunk. The jury thought it was a slam dunk. It's a 12-0 unanimous opinion. Second point, they say there's no evidence to support the jury's award of $120,000 in future medical. And the only evidence before the jury was Dr. Berliner saying that he needs an ESI for $5,900. That is totally untrue. One of the exhibits in the case, exhibit number 1, were the records of Dr. Chad Atkins, the chiropractor. This is the Reporter's Record, Volume 5, page 41. He lists out saying that in the chiropractor's opinion, Mr. Martinez, my client, is going to need yearly x-rays, a minimum of $180. He's going to need 10 to 30 visits per year on the average of $100 per visit. It was stipulated, and the U.S. Life Table said that my client had a life expectancy of 42 years at the time of this trial. So if you add up everything that Dr. Atkins says he's likely to need in the future, you get somewhere between $42,000 and $133,500. Add to that what Dr. Berliner says, $5,900 for sure. The jury's decision and award of $120,000 is less than the maximum that the evidence supported in the case.
Well, that wasn't how you argued it. You argued it that it should be 4 times past meds, right?
Yes, Your Honor, I did, and the jury gave 3 times past
Right.
meds. Yes, and I think they're within their rights to do that, because here's a man who's had $40,000 in medical. This case was almost 10 years old when it went to trial, and so 42 years in the future, I said just every 10 years it's going to be very similar to what it has been in the past, because all the testimony undisputed was his injuries are permanent and they're progressive. As he gets older, they're going to get worse and worse and worse, and he's going to need more treatment. So the jury could have, I think they should have awarded 4 times. They chose to award 3 times. More than fair. And supported by expert testimony, which I think you brought up a really good point, Justice Wilson. The case law is that the jury can determine, even though the preferred method is by expert testimony, without expert testimony, which we did have in this case, expert evidence from Dr. Adkins, the jury can determine from the past medical, the injuries to the client or the injuries to the plaintiff's current condition at the time of trial. They can infer, because he has permanent and progressive injuries, that for the rest of his life, 42 years, he's going to have these injuries and they're going to get worse, and then he's going to incur future medical. Issue number 3. Now this is the most pernicious one of all. Statute of limitations. First, the statute of limitations has not even begun to run yet, because much of this medical treatment that they complain about was done on letters of protection. Letters of protection that say that the doctor has only agreed to wait until the end of the case before starting to ask to be paid. The client agreed to that. It's in writing. So the statute hasn't even begun to run yet. Hopefully, after this and after y'all's decision, this case will be over, and then the statute will begin to run. And hopefully, your decision will be that they get full medical and the doctors can all get paid. Statute of limitations is an affirmative defense that belongs to my client, not to theirs. Not to theirs. They have no standing. They brought up a case, the 4th case, Allstate versus 4th, where the Supreme Court said the plaintiff had no standing to complain about the way that Allstate negotiated the plaintiff's medical bills and paid them under a PIP claim. In this case, the real party in interest, the insurance carrier, they have no standing whatsoever to try and claim, the statute of limitations has a run on all these things. And you pointed out very clearly, Justice Wilson, it's to the benefit of the insurance carrier or the defendant, whoever it may be, if this is the law, that once 4 years has elapsed from the time of the treatment, that the client can no longer recover for his medical bills, it's in their best interest to wait and delay. We have a 2-year statute of limitations for personal injury cases. If somebody waits until a month before the statute runs, like they got medical treatment the day of, like my client did here, he waits 2 years. It takes, if there's no Hurricane Harvey, there's no COVID, and he gets to trial in Harris County in 2 years, it's going to be, the statute of limitations might have run on a lot of his bills already. Then if they decide, we didn't like the jury verdict, like in this case, we're going to appeal. Now that's going to take another 1.5 years. The statute of limitations is going to run on everything. Guess what? They don't have to pay any medical bills. Well, that one stiffs the doctors. The doctors have have become involved in this case because of the negligence of their insured. So the doctors don't get paid. What happens if the doctors don't get paid? They don't do cases on LOP anymore. People that don't have insurance, and this state, we have a lot of people that don't have any medical insurance, they can't get medical treatment even though they're injured by somebody through no fault of their own. This is very, very pernicious. What they really want to do is, they already do this. We have the right to file an 1801 affidavit. That goes away just by filing a controverting affidavit. They injure somebody, and then they try and stick them with the debt that has been incurred to their own doctors, and that's legal, and that's what happens, and that's fine. Now they want to take it a step further and say they want to be able to stick the doctors because they want to be able to take the statute of limitations defense that belongs to the injured person and assert it against the doctors. I'm asking you not to allow that to happen. They talked about a windfall to the plaintiff. Escobedo says it's a windfall to the plaintiff if the plaintiff can submit medical bills that have not actually been paid or incurred. In this case, it's a windfall to the defendant if the doctors get stiffed for the money, for the treatment that they've done. The person who injures another person gets a windfall by stiffing the injured person's doctors. I'm begging you not to do that. That's all I have. If y'all have any questions, great. Otherwise, I'm done.
Give me the math again on back to point 2 of future meds.
Yes, Your
Give
Honor.
me Dr. Atkins' math again.
Yes, Your Honor. Let me find that. All right. Dr. Atkins says Mr. Martinez is going to need a minimum of 1 X-ray per year for 42 years at $180. That's $7,560. He's going to need.
I'm sorry. 1 X-ray a year at
at $180, Your Honor.
okay.
For 42 years, that's $7,560. He's going to need 10 to 30 visits per year at an average of $100 per visit, and that's a range of $1,000 to $3,000 per year times 42 years. So the range there is between 42,000, and 126,000. So if you add to the 126,000 the 7,560, that's 133,500, and then you add in what Dr. Berliner testified to, the ESI that is immediate, $5,900. That would put it up to about 140,000. The jury awarded 120,000.
And that was at 5 Reporters Record, page 41.
I'm sorry, Your Honor, can you repeat that?
Was that at volume 5 of the Reporters Record, page 41?
Yes, Your Honor.
Okay.
Yes, Your
Was
Honor.
there any testimony or evidence presented regarding the potential future cost of medical increasing or
No,
changing?
Your Honor. None. That's in today's dollars. And I think the case law says the jury has the right to realize that in 42 years, the price of this medical care, which goes up even faster than most goods or services, will be higher than it currently is. So this is just based on current today's dollars. All right, my time's up. Thank you very, very much.
Well, of course, it's also not discounted to present value.
Correct. That is correct. So my understanding is that medical care doesn't necessarily have to be future income for sure. It has to be discounted to present value. Thank you.
Thank you.
Thank you. I would like to take a brief minute to respond to a few points. The first being the issue of the future medical and the Dr. Atkins, the chiropractor's records in evidence at trial. There was no testimony provided to the jury about that record, and the argument was not based on that record.
But it was in evidence.
I do see that, but I think it's important to note that the medical records, generally speaking, based on the opinions of this court and the First Court of Appeals, tend to be conclusory as to causation. A lot of times, there's a number of cases that have held that medical records themselves are not sufficient to establish the need for that the need for future care is connected to the accident, because the statements tend to be just 1 line, 2 line, and they are considered conclusory. And a number of cases have held, including the Lara v. Bowie case. There's Sanchez v. Leja, and it goes all the way back to Hills v. Donis as well. In fact, that evidence is not legally sufficient to support the causation element of these awards for damages for medical care expenses either in the past or in the future. And so in this case, I think that that would apply. It is not something also that we saw in any briefing, but I do believe that that is the issue, that is an issue that would preclude that record alone from supporting this award of future medical damages.
Give me those cases. Give me those cases again.
Certainly. And I can give you the citations as well. I have them right here in my index of authorities. Give me one moment. The first one is the Hills v. Donis case, and that citation is the cause number in the 14th Court of Appeals is number 14-18-00566 CV. I can also give you the Westlaw citation if that would be helpful.
That'll get us in the ballpark.
Okay. The next case is the Lara v. Bowie case. This is a First District Court of Appeals opinion, and that one is cause number 012100484. I also believe I mentioned the Sanchez v. Leja opinion out of the First Court of Appeals, and that one is cause number 011900165 CV.
Thank you.
You're not suggesting the appellee waives something by not giving a citation when it's your legal sufficiency point, are you?
I simply mentioned that because it's not something I addressed earlier. And
I understand.
By way of
It'd be
explanation,
nice,
Your
but
Honor.
there's not briefing waiver on the other side if it's your burden, is there?
I understand,
Okay.
Your Honor. And I just wanted to address why I didn't mention that before. But I do believe the fact that the medical records standing alone without an expert to testify about them, courts have held, except in unique circumstances, if you were to have some sort of, long narrative, I would acknowledge that that could meet the standard. But by and large, the medical records we see, accident due to MVA. That is conclusory and not sufficient causation testimony to support an award of either past or future medical expenses, and that's what these cases have found. I believe that would hold true in this case as well. The only other issue that I wanted to address briefly is with regard to the issue of the letter of protection. If there were an agreement in the record at trial that said that we're tolling, our right to recover this until whatever date, I do believe that would probably be sufficient. I didn't see it. If it's there, it's there. I have not seen it though.
Okay.
And I don't believe that mentioning it in the absence of that evidence being present, and admitted at trial is going to affect or impact or should impact this court's decision on the issue of whether or not uncollectible medical bills are considered incurred under the statute. And I thank you very much.
Do you agree that the statute of limitations is an affirmative defense that lies with the plaintiff?
Yes, that is true. I also believe that the court, what Haygood was doing was saying a claimant should not be able to recover for expenses that they have not incurred, that they are not responsible for paying. And in that case, it was dealing with write-downs, but a bill that is uncollectible due to being time-barred is no different, as far as I can tell, in terms of not being, there's no responsibility, no exposure to that bill, and I believe it's the same issue. Is there no further questions? Thank you very much, Your Honors.
Thank you.
Cause number 1423-473 CV is submitted, and we're going to adjourn and have a change in panel.